Good afternoon, everyone. Welcome to our July 15th webinar about associations' duties, rights, limitations on managing common elements. This class really comes from a place of receiving a lot of questions from managers and board members of, we want to do X on the common area, but are we allowed to do this? Is this something we can do? And so it's, I think, some of it's going to be a refresher. Some of it might be things you weren't aware of, but I think this is going to be one of those kind of all-encompassing classes that'll help you with figuring out whether or not you should or should not be doing something and giving you an idea of where the association is at any given point in time when it comes up, with ideas about things to do with the common elements. But before we get started, it's comedy time. This made me laugh so hard, I have to tell you. Hopefully y'all think it's as funny as I do. But my name is Alina Gilbert. I will be presenting today. So hello, everyone. Welcome. And of course, thank you for taking the time to join us. You should be seeing on your screen the PowerPoint of this man and his dating profile, which I love. And off to the left is the presenter. Hi, that's me. To the right, you will see a little icon for chat. You will click on that. If you have questions, you can type them in, throughout the presentation. I am saving them for the end to answer because first, I want to make sure we go through all the materials. And two, sometimes you ask questions and then they're answered in a different slide. And so, they're already answered by the time we get to the end of the presentation. So I will save all the questions for the end. If you have any audio or video issues, during the presentation, there is a little button at the bottom that says audio or video issues. Click on that. It's going to take you through a few steps. Hopefully that resolves the problem for you. You will get one CMCA credit. It'll be automatically generated for you for attending the class, assuming you stay on, for the whole time. It will be emailed to you within the next probably 24 to 48 hours max. And just a word of caution, most of you already know this, but some of you may not. When you get the email with the picture of your certificate, please make sure to save that picture somewhere because it disappears after 30 days. Something with the webinar platform, I don't know what, something stupid. It makes it disappear. So please save your picture of your certificate so you can pull it up later. Otherwise, you are going to panic and say, where's my certificate? As a reminder, we are recording today's presentation and it can be watched at any time by anybody. So if you find this to be extremely interesting or something that you think someone else could use, feel free to, let other folks know that, hey, there's this webinar that I really liked. You should watch it on the ACE YouTube channel. And the only difference between watching it now and watching it later is that they cannot get credit for it, like you are getting credit today. And then finally, last but not least, at the end of the presentation, we do have a survey that pops up. Most of you are familiar with that. It asks for your feedback, comments, what you thought of the class, the materials, the presenter, all that good stuff. So if you have a minute, you have the inclination, we do appreciate any feedback we can get. It helps us kind of improve our classes for next year, which, by the way, we are already working on 2027 education. It's almost done. You will see it on our website probably in the next couple of months. So you can start signing up once you see it. So very exciting, another wonderful year of education. But let's go ahead and get started on what we came here for today. We are going to talk about managing, maintaining, etc., the common elements. And before we get into all of that, we need to talk about what common elements are. And I think inherently everyone's thinking, it's Alina, it's that property that everyone has access to by virtue of living in the community. It's common to everyone. And that is the right answer, but it is not the answer we get when we read the statute, when we read the Colorado Common Interest Ownership Act. Oddly enough, what the Kiowa says is for condominiums, it's different, right? For condominiums, it's all portions of the property other than the units, but also designated to be owned by the homeowners. In other words, in a condominium, the common elements are owned by the homeowners as tenants in common, and they all have this undivided share of the common elements. Kiowa also says if you have a community that where the homeowners do not own the common elements, it cannot legally be considered a condominium. Okay, so Kiowa actually doesn't care about the usage of it. Kiowa focuses on the ownership of the common elements. And by the same token, with a planned development, which is, your single family homes, your townhomes, your patio homes, it's any of the properties where your homeowners actually own the land and they own the structure. With that one, Kiowa says it has to be it's real estate that's owned or leased by the association other than the units themselves. So this is really the fundamental difference in common elements between condominiums and our planned developments. And I know you're thinking, well, maybe you're not, but I've had people ask me, hey, so what happens if we've got these stacked condominium units and the declaration says that the association actually owns the common elements or owns the properties? And I say you've got a pretty screwed up association, and there's a lot of problems that it's going to encounter down the road. And perhaps that's something you want to consult with legal counsel to try and get resolved if at all possible. Your declaration, of course, and the plat maps, condominium maps, all also contribute to the definition of common elements. Sometimes the declaration will list out specific components that are common elements. If you've ever looked at, especially a condominium map or townhome map, you will see labels like GCE, LCE, so general common elements, limited common elements, and that can be really helpful because sometimes it's hard to tell. For example, in a condominium community, sometimes it's questionable whether the attic is going to be part of the unit, whether it's a common element. What is it? We don't know based on the definition. And a lot of times, if you look at the map, it'll label the attic as an LCE, or it won't, and then we'll know it's part of the unit. So it is definitely helpful and enlightening to review the declaration and the maps to get additional definitions for your common elements. Okay, so in general, that is what a common element is, and under Kiowa, and of course you have to look at your documents. So let's look now at the statutes, well, mostly Kiowa, about what associations have to do, what they can do, what kind of authority we have with respect to common areas in the community, whatever they may be. So the first part, we're going to talk about maintenance and use of common elements. The first little check mark talks about use and maintenance, but Section 302 of Kiowa is a great provision. It basically says, hey, unless your declaration says something to the contrary, associations have these, and it's got a list of rights and duties. And I copied down some of the ones that talk about or impact common areas. So the first check mark says associations can regulate the use, maintenance, repair, replacement, and modification of the common elements. So that is something that an association can do that unless your declaration says you absolutely cannot do that you can do even if your documents are silent. It's a great provision. It also talks about adopting and amending rules and regulations. And honestly, the rules and regulations go hand in hand with the above provision, because how do you regulate use? Well, you adopt rules, regulations, guidelines, policies, whatever you want to call it. It's generally the same thing. So that's how you regulate the use, right? You adopt rules, and they talk about appropriate and inappropriate behavior in association properties. And so a lot of times I've seen angry homeowners question boards or question management about, well, who gave you the right to adopt this rule? There's nothing that says you can do this. You did it illegally, the regular spiel we hear. And the answer is, even if our documents are silent, the law says we can do it. We have this right under the statute, under Section 302 of Kiowa, and that's what says we can do it. The other things mentioned are cause additional improvements to be made to the common elements. So if we have a pool and now we want to build a diving board for the pool, that's an improvement, and the association can go ahead and do that without having to go through homeowner approval, unless the declaration says something contrary to that. So we can cause these improvements to be made. We can add railings to the common element stairs, that go to the units, or, whatever else it is, we can add improvements to that. We can, and just real quick, it is a post-Kiowa provision as far as adding additional improvements, which means if your community was created before July 1, 1992, this doesn't apply to you. So the question then, Alina, what do we do if we're a pre-Kiowa community? We don't have any language about this in our declaration. Does that mean we can't do anything with respect to the common elements? Well, the answer is, if you add improvements versus simply maintaining, it could be subject to challenge if you don't have specific authority to do that in your declaration. And now if you're adding improvements because it's mandated by law, I don't think that's going to expose you to liability. But I think if you're adding improvements like the diving board example, and there's nothing in your declaration that says you can add improvements to common elements and you're not subject to this provision of Kiowa, I think it could be subject to challenge. So it's important to keep in mind, if you're, a pre-Kiowa community, that not everything is like an automatic right for pre-Kiowa communities. The other one is grant easements, licenses, leases, concessions over common elements. When do we do that? When do we grant easements or leases? Well, let's see. We grant Comcast an easement to bury their lines. We can grant an owner an easement or a license to extend their deck, and it encroaches a little bit on the common element space there. We're allowed to do that. We're allowed to do that because this provision in Kiowa says we can. But if you are a pre-Kiowa community and this doesn't apply to you, you want to make sure that your documents have this language. If they don't, again, there is an argument to be made that the Colorado Revised Nonprofit Corporations Act does have some authority for nonprofit corporations to grant easements. However, that is also going to be subject to challenge because Kiowa has what we call a supremacy clause, which means to the extent that, Kiowa conflicts with other statutes, Kiowa is going to prevail. So there could be an argument made that if you grant an easement and you're a pre-Kiowa community and your documents don't allow for it, you cannot rely on the Nonprofit Act and therefore you cannot grant easements. I don't know how realistic it is, but it's still a risk. So I would encourage associations that are pre-Kiowa to double check your documents and make sure you have easement language in there. Most of them do, not all of them. So that's just something to keep in the back of your mind, and a little red flag for you if you don't see that language. So Section 302 also says, unless your declaration prohibits it, you can impose fees for use, rental, or operation of common elements. What does this mean? That we are a community with a swimming pool, and now I can charge my homeowners extra money to use the swimming pool. No, that's not exactly what it means, although it kind of sounds that way, doesn't it? It means that if I'm going to have aerobic swimming classes in the pool, I can charge extra for that, for them to use the common element for that purpose. If somebody wants to rent the clubhouse for a party, I can charge fees and rental costs for that. So that's what that means. It means you can charge additional fees when it's something over and beyond what is being paid for through regular assessments. But that is a right that you have under Kiowa, whether or not your document speaks to that. So that's a good thing too. Now we're just going to keep talking about maintenance. That's all we're going to talk about. Now we are on section 307 of Kiowa, and this entire section only applies to post-Kiowa communities. I know I put it there in the first check mark, but really all of this only applies to post-Kiowa communities. But I'll get there in a second. So unless otherwise provided in the declaration, the association is always going to be responsible for the maintenance, repair, and replacement of common elements. And the association is always going to have a right of access through units as necessary for common element maintenance, repair, and replacement. A lot of times, especially with older documents, the developer, they miss the point of allowing the association to get access if they have to reach a common element through a unit. And homeowners are like, you don't have any right to enter. Well, if it's a post-Kiowa community, they absolutely do have that right, because this is the provision of Kiowa that says they do. That doesn't mean you should be knocking down people's doors to go in there and check their electric panels, but it does mean you're not going to be trespassing. However, just as an aside, and if you talk to any one of our litigators, they're going to tell you, don't do it. Don't do it if the homeowner is not giving you approval. It's not worth your safety. You don't know what's behind that door. People have guns, people have big dogs, people have weapons. I mean, you just don't know. So don't risk your own personal health and safety to do this. Get a court order, have a police officer there to keep the peace. Now, the association being responsible for maintenance, repair, and replacement of common elements. So this is also common law, which means it's just law precedent established over the years through various cases, but that we have a default. And you may have heard me talk about this before, but everyone maintains kind of what they own. So unless you have an agreement shifting that, what's the agreement? It would be the declaration in this case. So in a planned development, since the association owns the common elements, it would have a duty to maintain all the common elements unless the declaration shifts any of that to the homeowners. By the same token, you have homeowners who would be responsible for maintaining everything they own, unless the declaration shifts any of that to the association. So let's take a look at something like patio homes. I like patio homes. Typically with a patio home, a lot of times we see a zero lot line, which means the homeowner owns kind of the structure, the foundation, everything below it, but everything outside the foundation is not part of the lot, and it's considered common element owned by the association. And so arguably under this section, the driveway would be part of the common elements, even though, it only services this one home. It'll be part of the common elements. And unless the declaration says owners have to maintain their driveways, it's going to fall on the association because it is a common element, period, end of story. Regardless of what common sense may tell you. On the other hand, if the declaration says homeowners are responsible for snow removal from the common or from the driveway, okay, great. So that's shifted to the homeowners, but the rest of it is still going to be on the association because that driveway is going to be a common element. So it's important to remember this, and I kind of talk about this every time I teach a class on figuring out maintenance as well, because we always have to start with the presumption of you maintain what you own, you insure what you own, unless it is shifted to someone else through the declaration. And that's really where we start with all our analyses of who has to maintain what. I just had an exchange with a board that is it's a townhome community. but the shared walls and the lots kind of extend out partially. So like they have the driveway, they have a little walkway from the driveway to the front doors, and the lot line ends somewhere in the middle of the driveway. So part of the driveway is a common element, part of it isn't. Go figure. The question really was, who has to maintain the little walkway from the driveway to the front door? And there wasn't anything in the covenants that specifically addressed that. So when, I had to look at their plat map to see how the lots are shaped to make sure they're not zero lot lines and to see kind of how far they extend. So once I realized that these little walkways were part of the lot and not outside the lot boundary, the analysis was easy. I said, hey, your documents are silent, but this is part of the lots. And absent anything shifting this from the homeowner, they have to maintain it. So that was the way the analysis progressed with that type of situation. All right. The other issue with maintenance is, of course, you always have to look at your declaration. And sometimes I will say the plats, sometimes they have something in there. But the declarations typically have maintenance provisions. And unfortunately, as I'm sure you have all experienced, sometimes they are less than completely clear on the issue of maintenance. And you're reading it, you're going back and forth, you're looking at other provisions, and it is still not clear. And so there needs to be some sort of an interpretation of the declaration. So most of the time you reach out to legal counsel to get that for you. And how do we do it? We can create maintenance charts for the communities where we basically list out all the various components and who has to maintain it, owner or association. We can draft legal opinions on specific issues of, who has to maintain the window well. Okay. And sometimes it's just so bad that there's really no good way to define it, because you have one provision saying one thing and then the next provision says something completely opposite to what this provision said. And so sometimes the best case scenario is we need to propose an amendment to just remove this language and replace it with something that's more clear. But those are the different ways, that we interpret the declaration. I suspect most of you have been through that, where you just couldn't figure out who has to maintain what. And then you go ahead and reach out to legal counsel for the community so that you can get clarification. But the point here is that regardless of what, we talked about in Kiowa, the declaration can shift some of that, right? So because those provisions were unless otherwise provided in the declaration, which means if the declaration has something more stringent or less stringent, we're going to have to go with the declaration requirements. So that is always important to keep in mind, as we should always be looking at the declaration first on this issue, at least. And then if it's completely silent, we can refer back to the statute as far as maintenance obligations and see what kind of defaults we can take advantage of. All right. Okay, let's move off of maintenance. I think we've talked about maintenance long enough, and let's talk about the other fun thing, insurance. Yay. I know most people hate insurance, so this isn't going to be very long, but we do have Kiowa provisions. Again, these only apply to post-Kiowa communities, but they are very specific, and these are not provisions that can be modified by the declaration. They don't say unless otherwise provided. They say this is what has to happen. Association, you are required to insure all common elements, That includes limited common elements, okay? So if your declaration says homeowners have to insure their limited common element balcony, doesn't matter. Association under the law is required to ensure the common elements, no ifs, ands, or buts. However, if your declaration, if you're a pre-Kiowa community and your declaration says something different, you follow what the declaration says. So for pre-Kiowa communities, you follow exactly what the declaration says. If your declaration is silent, then we fall back on the common law, which says if you own it, you insure it and you maintain it. And so that would be the way we would interpret the documents and the way we would interpret the law with respect to insurance. Now, there's a lot of nuances when it comes to insurance, and I've taught, I mean, I got a 2-hour class, I talk about insurance. We're not going to do that to you today. And this is really the only thing I wanted to mention is there is a Kiowa requirement to insure the common elements by the associations that were created after July 1, 1992. All right, and perhaps something more problematic, I think, at least these days, is access to common elements. A couple years ago, we had some legislation that added Section 302.5 to Kiowa, applying to all communities regardless of when you were created. And it basically says associations have to protect owners' ability to use common elements, and they cannot unreasonably restrict or prohibit access to the common elements. Okay. So how does this play out? What does it mean? Well, ultimately, it means you have to allow free use of the common elements. However, you can restrict use if you're providing maintenance, repair, or replacement, but only if necessary to protect the safety of the individuals or the workers or the structural integrity or the condition of repair. So let's use an example here. I'm going to go back to the swimming pool. We are replacing the water pump in the swimming pool. We can close the pool for that because obviously if we let people use the pool, it might not have any water in it and they're going to jump in and hit their head on the asphalt, and that's that. So we obviously want to, prohibit entry. Furthermore, if someone's actively replacing parts of the pool, parts of the equipment, again, somebody coming in and disturbing them, not the best case scenario. So we could restrict access to the pool in that circumstance. However, the next section says, if you're restricting access for more than 72 hours, so if we're going to close this off for more than 3 days, got to do some stuff. One is you have to provide written notice. It can be electronic to all the owners, explaining why the pool is closed, when you anticipate it will reopen, and then you have to provide either a phone number or an email address where they can email or call for questions. Okay, so you have to provide all that information. The other thing you have to do is post visible signage at all access points of this amenity that has exactly the same information that I just listed. So again, you would have, maybe it's a sandwich board, maybe it's a plaque, I don't know, whatever you have posted at the pool entrance or entrances has to say, the pool is closed for water pump repairs. We anticipate it will reopen in 5 days. For questions, email, blah. And typically, typically it's the community manager that gets their email or phone number listed on there. Why does this exist? It exists because, it's easy to get the ears of the legislators because some homeowners came and complained that, my board is not letting me use the hot tub. They're just closing it off and I can't use it even though it's there and I'm supposed to be using it. So what we had was some associations were like, you know what, we have 2 people who use this in any given year. It's not worth the maintenance cost. We're going to shut it down for this season so we don't have to absorb the costs for really 2 people using it. And the legislature thought that that was not good because we have the hot tub. Got to allow people to use it. It's an amenity. So you cannot just say, we're not going to maintain this. Same thing with pools. Yes, it's expensive. And I have communities that I've talked to that are like, well, we haven't opened the pool in 5 years. Well, guess what? you're going to have to open the pool because you're violating Colorado law and you're exposing the association to liability if you don't. I've had questions along the lines of, does this Kiowa section mean that we cannot shut down or we cannot close the outdoor pool for the winter? Well, that's not what it means. You have to focus on the unreasonable restriction portion, and it is reasonable to not provide access to an outdoor amenity during the months that it cannot be utilized. However, to be safe, should you be placing a sign, which I'm sure most of you do, at the pool entrance saying, closed for the season, planning it will reopen on Labor Day or whatever, here's the email for the manager if you have questions. I mean, that's the safest bet, is to do that, as well as sending out, in your newsletter, something that also provides this information. I think that is the best way to comply with this provision. I've also had a situation where these are war stories. There was a community that had some open space that it didn't feel homeowners should use because there were reports of like snakes in there and whatever else. And so they closed it off and said homeowners could not have access to it. And they weren't real happy when we said, hey, you don't get to do that. You can put up warning signs that say, danger, beware of snakes, enter at your own risk, but you can't just tell people they can't use it when it's part of the common elements. That violates section 302.5 of Kiowa. That created just like the biggest brouhaha I have seen in a very long time. It was, some homeowners wanted it open, some wanted it closed, that it was just this community-wide panic, which I still can't figure out for the life of me. But, this provision does have some implications with respect to use of common elements and whether or not can we reasonably close off common elements that we feel are dangerous. We don't have any court cases on this yet, but just remember, don't close off your common elements because the board doesn't want to pay to keep it open. You can't do that anymore. All right. Now, let's talk about transferring common elements. So for communities that are post-Kiowa, post-1992, Kiowa says no ifs, ands, or buts, doesn't matter what your declaration says, but you cannot transfer common elements unless you get approval from owners who represent at least 67% of all the votes in the association. So it's pretty much the same approval you need to amend most declarations, 67% of all the votes. Okay? There's no way around this. It doesn't matter what the declaration says, unless the declaration has a higher requirement. Some declarations might say you need 90% of the votes to approve transferring common elements, in which case, yes, you have to follow that. It just can't be less than 67%. So that could be a struggle. And there are quite a few associations that I have seen want to transfer common elements. For example, I had a community post-Kiowa, it wanted to transfer some of its common element tract to the local metro district, so the metro district could come in and maintain it. The district didn't want to maintain it unless it owned it. And so the deal was, if you transfer it, we'll maintain it, otherwise we won't. And this community could not transfer it without the approval of 67% of their homeowners, which they could not get. Not because owners didn't want it, but because there was just too much apathy for them, to get the 67%. So it is a provision to keep in mind, and it is definitely applicable to all post-Kiowa communities. What about pre-Kiowa communities? Well, those are a little bit easier. You just follow whatever your declaration requires. So if the declaration says the association can transfer property and there's no requirement for owner approval, then that's what happens. What if your declaration is completely silent on the issue of transferring property? Well, we have the Nonprofit Act, and it does say that that association, nonprofit corporations can buy and sell real estate. So if you are a community that is a planned development where the associations own, where the association owns the common area tracts, then that's real estate the association can arguably transfer without homeowner approval based on the Nonprofit Act. But again, remember our earlier conversation where I said Kiowa has the supremacy clause. So does this mean that the 67% will trump? Not necessarily. But again, we do prefer that you have that language in your declaration as opposed to relying on the Nonprofit Act. And that is the transfer of common elements. And when I say transfer, I mean the ownership. I don't mean like granting leases or licenses. I'm talking about just transferring the ownership of the property to someone else. All right, now I want to talk about some other issues that we haven't talked about yet. One is changing the use of common elements. And I know we looked at the provision in Kiowa that talked about using the common elements, that the associations can govern the use. Governing the use means governing how it is used by homeowners, by residents and guests. What I'm talking about is taking the swimming pool, filling it in, and making it a basketball court instead. You are taking the fundamental use of the amenity and changing it into a completely different amenity. What happens in those cases? So, and in those cases, the first thing you want to do is you want to look through your documents, through the declaration specifically, to see, is there anything in here that gives the board authority to change the nature of the common elements, to change how they are used in a sense of creating something completely different? If there isn't, the next step is we need to look at both the map and the declaration again to see, is this something, this amenity, is it mentioned in here? Is it depicted on the map? So if it's the swimming pool, okay, is the swimming pool on the recorded plat map? Is the swimming pool mentioned specifically in the declaration? If either one of those is yes, we have a big problem because this is a recorded document. And so people who purchase in the community have a reasonable expectation that these amenities will be in the community when they purchase and that they will not go away. Unless we have a provision in the declaration that says they can go away, then the homeowners are purchasing it with the expectation that these are amenities, they're in the community, they will stay in the community. So what do you do in those types of cases? Generally, the most common approach is proposing an amendment to the declaration that homeowners have to approve, which gives the board authority to change the nature of the common elements and to change them from one amenity to a different amenity without having to go through homeowner approval or getting homeowner approval from a reasonable number, like a majority of quorum, or something like that, or a majority even of all. 67% of all is typically not going to be feasible unless it's a small community. But that's generally how it's going to be addressed. If a community really wants to get rid of the pool and put up a tennis court or, pickleball court, and they don't have the authority to do that in their declaration, and on top of that, we have the pool in the map and it's mentioned in the declaration, we're going to need an amendment before the association would be able to do anything. Oh, and in the meantime, you got to keep that pool open, right? Because we can't cut off access to common elements except for when we're maintaining and repairing. So changing use of common elements is not necessarily an easy thing, especially when your documents don't speak to it. Let's talk about limited common elements as well. So limited common elements, as I said earlier, they are common elements. We have really two basic categories of common elements. We have our general common elements that are open to everybody, and we have limited common elements that are open to less than everybody. Sometimes it's just one owner, sometimes it's more than one, but it's always less than all. So that's by definition a limited common element. So again, we have, what kind of limited common elements do we deal with? Well, balconies and condominiums, parking spaces that are assigned, right? So those are limited common element garages. Sometimes certain utilities that run through the unit are labeled as limited common elements and not part of the unit. So it could be anything. And so limited common elements come into play a lot in communities. One is because there's a perception out there that, the owners are responsible for some of their limited common elements, like the utilities running through their units. Well, and that's not going to be the case unless the declaration specifically says it is. So, be careful with making that kind of an assumption. If it's a limited common element, you still have to have maintenance or whatever shifted to the homeowners for them to become responsible for them. So what about assignment? Assignment of common elements. Well, we go back to, are you allowed to assign? Well, if you're a post-Kiowa community, yes, you can assign regardless of, even if your declaration doesn't speak to it, because that was, Section 302 that we talked about, and it had that assignment, deeding, whatever. Not deeding, sorry, the leasing and assignment of common elements. So can an association take a parking space that's a general common element and assign it to a unit owner to use as their own? Again, unless the declaration prohibits it, which sometimes it prohibits it in a roundabout way. So it might not specifically flat out prohibited, but it could have language that says, parking spaces are to be used by all owners on a first come, first served basis. If you've got that kind of a language, you want to be careful because it says all owners, first come, first serve. So it doesn't say unless assigned by the association. So those types of provisions are problematic. But if your documents are silent, the association does have authority to assign parking spaces, the garages, the carports to individual owners. If you're a pre-Kiowa community, you're going to have to check your declaration because that provision of Kiowa isn't going to apply to you. Now, what about changing assignments? How do you change? Like, I have parking space A, and then Betty has parking space D, and her and I want to switch parking spaces. What does that look like? Well, Kiowa has a provision for that, and you follow that provision unless, you have something different in your declaration. But ultimately what it says is, first of all, the board has to approve that, and both owners or all the owners who are part of this exchange have to approve it. And then there has to be a document that's drafted where the switch is memorialized, and then ultimately it gets recorded with the county so that any future owners of the pertinent units are going to be bound by that exchange. And from now on, will be required to use, this parking space or that parking space. Nothing creates a bigger mess than owners deciding they're going to switch parking spaces without telling anyone or recording anything. And then they sell their unit, and they put something in their deed that, oh, you get to use this parking space, and that's not the parking space that they were assigned. And then you have all this mishmash, and in the end, you have this poor association saying, well, we've got Bob who just bought a unit that just did some title work, and it says that his spot should be X, but X is being used by this other owner, and what's going on? It's a horrible situation to be in for any association, and it's extremely expensive and time consuming to get it all figured out and then resolved. So ultimately, if you do have people who want to switch their limited common element parking, or what it could also be, of course, their storage units, I guess, then make sure that that's something that does happen with the board's approval, with the appropriate documentation and the recording. You obviously want to go through legal counsel to make that happen. Maintenance and repairs. Well, again, we talked about that. It is the association unless it is shifted to the homeowners through what? Through the declaration. And then the final one is there's a whole bunch of stuff we have to allow owners to put on certain limited common elements that we can't prohibit anymore. For example, the EV charging stations, we have to allow them on the property that is owned by the homeowner, but also on the limited common elements. So if they're in a condominium, but they have an assigned parking spot or garage space, we have to allow for them to put the EV charging station in that parking space or in that garage. We can't prohibit that anymore. Satellite dishes. This is an age-old thing, right? Those, you have to allow them on the person's property and on their exclusive use areas. And this is a federal law. It's the FCC. So what does that mean? If I'm in a condominium community and I want a satellite dish, you can't tell me, HOA, that I cannot put it on my deck, which is a limited common element. You can tell me it has to be completely within the playing or the fields, the horizontal fields and the vertical fields of my space, and which the deck or the balcony, and that it can't protrude outward from the deck or balcony because that's already a general common element, but it has to be completely within the confines of the deck. But you can't prohibit me from putting it there. Our most recent legislation, for those of you who don't know, now says we can't prohibit portable solar panels on condo balconies. Have to allow them. What are portable solar panels? I don't know that I've ever actually seen them, but from what I understand, they're like these, they flop open, they're on a stand. A lot of times you have to secure them to something or put them on I don't know if it's a tripod. But at any rate, you cannot prohibit them. You can have certain regulations, but ultimately you cannot prohibit them. You can't even really require approval of them. But you can have a policy that talks about that. If that's something that your community wants to do, I would recommend you make it part of your regular solar panel policy, so it addresses all solar panels. And then finally, flags. Remember, flags can't prohibit them on limited common element balconies, although you can prohibit signs. I don't know what the distinction is, why the legislature did it that way, but ultimately we have to allow flags on balconies, just not signs. So those are all things that we as associations cannot prohibit. We can regulate them slightly. A lot of times we can regulate the dimensions, the aesthetics sort of to a point, but generally with these things, of course, there's very little room to move. So when it comes to limited common elements, associations have far less rights as far as controlling what's there than it does, of course, with the general common elements. Now, there's a lot more stuff we could talk about today with respect to common elements. There's like an endless amount of issues that come up. I focused on these because I think they really represent the most pertinent issues that we come across today, but that's not to say that there aren't any other ones. So if you do have other issues, of course, you should be reaching out to the association's legal counsel and asking those questions. So now we have about 12 minutes, 11 minutes for questions, and we have quite a few. All right, is the definition of common elements different for pre-Kiowa communities? No, it's exactly the same. The definitions apply the same to pre and post-Kiowa communities. We have townhomes, if I could talk, we have townhomes with a private underground garage that sits within a commercial garage. Owners built storage units that were not part of the original drawings. These units are against fire code. What are our rights as an HOA to remove these units from the common garage? If they are building them on common area, the association has every right to remove them. I would absolutely give them notice. I would absolutely ask them to remove it. Otherwise, if they don't, the association can remove it. You can charge the cost back to the homeowner in most cases. The one thing I'd be very careful with is the stuff that's there, because we can't just toss it. We still have an obligation to store it. So yes, you can charge them for storage costs and not give it back to them until they pay it. But ultimately, if it's on common elements, it's like me going to my neighbor's lot. I'm going to plant a tree on their front yard and be like, you can't touch this. Well, of course they can. They can uproot that tree and remove it. It's their property. Same type of analysis. All right. I want to clarify, did you say that foundations are the responsibility of the homeowners, not the HOA? I did not. It's going to depend on if it is a planned development, which is your townhomes, patio homes, single family homes. The foundation is going to be owned by the homeowners, and it will be their obligation to maintain unless the declaration for the community says that the association has to maintain them. Let's see. Maintenance chart. Does it belong in the declaration since the declaration is so hard to modify? Well, a maintenance chart is generally, I define it as a legal opinion. It's the attorney going through your declaration and providing you with their opinion as to who has to maintain what. And so then you treat it like a legal opinion, although typically we're going to say it's not attorney-client privileged. You can distribute it to homeowners so everyone can have this chart and hopefully cut down on the questions. For us, a lot of times when we rewrite governing documents, we will add a chart as part of the declaration to remove any kind of verbose provisions that talk about it. I think a chart is a million times easier to understand. So that's what we do when we rewrite them. But if you're not rewriting and you just want a chart, that's going to be a legal opinion of the obligations. All right. Can you speak to identifying and listing common elements and limited common elements impact an association's architectural controls and possible conflicts? That one is a very big, broad discussion. I wouldn't know where to start with that. So I would say if you have specific questions, maybe reach out to legal counsel. It's just too broad of an issue to discuss in the last 5 minutes of this class. I'm sorry. For example, if an association has tennis courts in disrepair, must they repair? Very expensive. Or could they choose an amendment or resolution to take it out as an amenity and do something different with that area? They have to repair it. They have to open it to use by the homeowners, regardless of how expensive it is. If they want to change it to a different kind of amenity, again, you'd have to go through the analysis we talked about just previously about changing the actual scope of what the amenity is. And so they'd have to go through that analysis with their legal counsel to see if that's something they could do without amending the declaration. If not, they'd have to amend the declaration. But in the meantime, they would need to open those tennis courts. They would need to refurbish them, fix them, and open them. And this is the type of thing that really created the legislation. Was the associations were like, we can't afford this. We're not going to open it. And that upsets some homeowners. What is a silent declaration? I'm sorry if I misspoke. It's not a silent. It's when the declaration is silent as to a specific issue, not a silent declaration. So my apologies if that was not clear. What if the declarations state no satellite dishes are allowed? Does the federal law win giving the right to install satellite dishes? Absolutely, it does. And you do not want to violate that federal law. All right. In other issues, limited common element states you must allow flags on the condo balconies. Our rules prohibit that. Do we need to change the rules? Which section of Kiowa is that? Yeah, I don't remember exactly off the top of my head the specific section, but you do need to change the rules. Those are not enforceable. If you try to enforce them, the association will be exposed to liability because it is violating state law by doing that. Feel free to shoot me an email and ask me for the specific section. I can forward it to you then. Our condo association has a single family home with a garage on it. The owners in the main condominium building do not want to pay the exterior maintenance costs for the garage belonging to the single family home. Currently, the HOA is responsible for all exterior maintenance for the main building, the house, and the garage. We are a post-Kiowa community. Is there a way we can not have community dollars paying for exterior maintenance of the garage that services only the single family home? It is documented as an LCE in our governing documents. You would have to propose an amendment to the membership and get it approved, in which the maintenance for that garage goes to the single family homeowner. Otherwise, you have to follow what's in your declaration, whether it's reasonable or not. If there is a limited common element that needs maintenance and the HOA does the work to maintain, can it be charged back only to the unit it serves? Not necessarily. That authority would have to be in your declaration to charge back costs based on benefit. So you would need to review the declaration to determine if that's something that could happen. Does the HOA need to establish a written policy to remove attachments to limited common elements such as a heat pump, or can't it just notify the homeowners and then promptly remove it? For example, when the homeowner refuses to remove it after notice and fines. Understood that we need to store it. It depends. Honestly, it depends on what does your declaration give you the right to self-help? Have you tried all other enforcement options? I think this would be a very specific question to ask the legal counsel, because it's going to be so specific and based so much on your specific governing documents that the answer is maybe. Unfortunately, that's all I can give you. But yeah, you should have a written policy in place that talks about what can and can't be stored on your balconies, because otherwise, the courts don't like seeing associations try to enforce an unwritten rule, because they feel like there's not enough notice to the owner that that's something they can't or shouldn't do, because there's no written rules against it. So yeah, I think it's always better to have a written policy or written rules with these types of situations. I think we only have time for a couple of questions. The design guidelines say lots have a view. What is the HOA's responsibility to protect that view as a common or limited common element? So a view, generally in Colorado, there is no right to a view. Some states have it, like California, but Colorado does not. So unless that right to a view is protected in the declaration, you don't have that right. So somebody could build a home next on the neighboring lot and make it tall and blocks your view of the mountains. Happens. It depends on how the declaration is drafted with respect to the view. It's not a common element issue. It's an architectural issue more than anything, where if somebody puts an improvement on their lot that blocks the view of the neighboring lot, it becomes more of a, did they violate the declaration, and do we have to start enforcement proceedings? And I think, oh, last question, I think. We have a rule limiting homeowners to one pet at a maximum of 10 pounds, which the HOA board voted not to enforce. If it's a rule that you're not enforcing, all I'm going to say is get it off the books. Otherwise, you're exposing yourself to liability because you've got rules that the association's not enforcing. Take them out. Don't just let them sit there and not enforce them, because somebody's going to sue you over it. The neighbor's going to sue you saying, well, you're not enforcing. My neighbor has a giant Doberman and you're not enforcing the 10-pound rule, and you're going to have some liability exposure there. Okay, we are at 1 o'clock. We're done with the questions, and thank you so much for joining me, and please and do the survey if you have time. Thanks all. See you next time.